Mr. Barnett.
Justice Stevens, and may it please the Court, I have 2 points to make. First, the class of activities involved in this case are non-economic and wholly intrastate. Second, the federal prohibition of this class of activities is not an essential part of a larger regulatory scheme that would be undercut unless the intrastate activity were regulated. If you accept the government's contrary contentions on either of these 2 points, Ashcroft versus Raich will replace Wickard versus Filburn as the most far-reaching example of Commerce Clause authority over intrastate activity.
Well, on your first point, can't we infer from the fact that there's an enormous market, commercial market, for any given commodity, that simple possession of that commodity is a form of participation in the market?
It can be, or it might not be. If you possess an item that came from the market or is going to the market, simple possession could easily be a part of the marketplace. But if you're in possession of an item that you've made yourself that is disconnected from the market, it didn't come from the market, and it's not going to the market.
But it's fungible.
That the fungibility issue is in this case. But the fact that a good is fungible does not make it a market good, and it does not make the possession of that good an economic activity.
Well, Congress has applied this theory in other contexts. One is the protection of endangered species. Congress has made it unlawful to possess ivory, for example. Doesn't matter whether you got it lawfully or not. Or eagle feathers. The mere possession of it, whether you got it through interstate commerce or not. And Congress's reasoning is we can't tell whether it came through interstate commerce or not. And to try to prove that is just beyond our ability, and therefore it is unlawful to possess it, period. Now, are those laws likewise unconstitutional as going beyond Congress's commerce power?
Not if they're an essential part of a larger regulatory scheme that would be undercut unless those activities are reached.
Why is that different from this?
Because this class of activities, because it's been isolated by the State of California and is policed by the State of California so that it's entirely separated from the market.
Isolated and I understand that there are some communes that grow marijuana for the medical use of all of the members of the communes.
That class of activities is not before the court. That is actually before.
Oh, but it's before the court when you raise the policing of the problem by California and saying it's not a real problem. You brought it before the court.
But that class of activities could be if this court limits its ruling to the class of activities that is before the court.
Which is what?
Which is
an individual grower?
Individual who is growing it for him or herself. Who has a caregiver growing it for her.
Gee, what basis is there to draw it that narrowly? I mean, I guess we could say people whose last name begins with a Z. That would narrow the category too. But why does that make any sense?
Justice Scalia, we believe it makes sense because we are talking about a classification of activities that has been identified by the State of California and which is rational to distinguish
but
from...
But California hasn't identified individual growers. Communes are okay as far as California law is concerned.
Well, it's not entirely clear whether communes are okay as far as California.
Why wouldn't it be?
Because if, in fact, commercial activity is taking place, if buying and selling is taking place...
No, they're not buying and selling. I mean, you can't prove they're buying and selling. There's just a whole lot of people there with alleged medical needs.
I don't understand. Is there any authority in the Commerce cases for an X which is there in the middle of a state? It doesn't move one way or the other. Now, Congress's power does extend to the X if the state doesn't say something about the X. But if the state says something about the X, then Congress's power does not extend to it. That's hard for me to accept because I don't see whether it's commerce or not commerce, whether it affects something or doesn't affect something, doesn't seem to me to have much to do whether the state separately regulates it, and I can't find any support at all for that in any case.
The support would come from the exception to Lopez and Morrison that the government is urging that the court adopt, that that the Congress can reach non-economic activity that's intrastate, that's wholly intrastate, if doing so is essential to a larger regulatory scheme that would be undercut if they can't reach it.
Well, here they say, look, I take it you're using this because I was going to ask you. You know, he grows heroin, cocaine, tomatoes that are going to have genomes in them that could at some point lead to tomato children that will eventually affect Boston. You know, oil that's never, in fact, being used, but we want an inventory of it federally. You know, I can multiply the examples, and you can too. So you're going to get around all those examples by saying what?
By saying that it's all going to depend on the regulatory scheme, what the purpose of
So now what you're saying is in a Commerce Clause case, what we're supposed to do is to start to look at the federal scheme and the state scheme and see, comparing the federal scheme and the state scheme, whether given the state scheme, the federal scheme is really necessary to include this. That's a task, and I'm trying to make it as complicated as I can in my question.